In other words, any legislation that you pass must, in terms of its content, be able to coexist with the Constitution and its values. And we know that in terms of Section 2 of the Constitution, we have what we term in law the principle of constitutional supremacy. And what Section 2 says is that the Constitution is the supreme law of the land. All law or conduct inconsistent with the Constitution is invalid. So we have a clear, sweeping statement of the supremacy of the Constitution. We also have a provision in the Constitution that says that flowing from the principle of constitutional supremacy and the fact that the Constitution is the overarching law of this country is the principle that says that when interpreting any legislation and in developing the common law meaning the law that is not enacted in terms of legislation, but principles that have come to us in terms of a heritage of legal systems. So what it says is in interpreting the common, in developing the common law, or in interpreting any legislation, the court must give effect to the purpose, the purport and the values of the Constitution. So the dilemma we all now have is this, and I go back to the following. If we are guaranteed freedom of our religion in the context of legislation passed under Section 15, then indeed none of us has any quarrel with the process. But the reality of the situation is that any legislation passed under Section 15 has to pass constitutional muster. It is subordinate to the Constitution, and it's subject to being assessed, analyzed, through the prism of the Constitution. So if anything in the legislation does not sit well with the Constitution, it must either be set aside, or the court must read into the legislation, read into it provisions that will render it compatible with the Constitution. And that then is the fundamental dilemma. Because the requirement that any legislation must comply with constitutional values and must not be inconsistent with the Constitution then says, can we be comfortable that the principles of Islamic Sharia that are enacted in terms of legislation in this country, will those principles stand? Or will they be trumped by constitutional principles? And we know, many of you do, but as lawyers we know that the value system of the Constitution of this country and the value system of the Islamic Sharia do not coexist peacefully. There are fundamental dichotomies between the two. A classic instance, of course, is the one that's been raised already, the context of a talaq, which of course brings about the dissolution of a marriage by mere pronouncement of dissolution by the husband using the word talaq. And we know that if in fact the right of a husband to terminate a marriage by the pronouncement of talaq is now enacted in terms of a law of our country, then if the dispute over that dissolution, if that marriage dissolution dispute has to go to court, what is it that will prevent a spouse from within the Muslim community who is not quite happy with the husband's pronunciation of talaq and the resultant dissolution of marriage under Sharia law from in fact saying that the Constitution guarantees the principle of equality, the principle of talaq that allows a husband to dissolve or terminate an Islamic union or marriage is not one that extends to a wife. And the Constitution guarantees equality and guarantees the equal protection of rights. So I don't now recognize the husband's right to pronounce a talaq in accordance with the founding values and in accordance with the principles of the Bill of Rights set out in our Constitution. So the court must now read into the legislation that says that a husband is now entitled to dissolve a marriage by the pronouncement of talaq. It must read into that a substitution for the word husband with spouse. So a spouse is now entitled to dissolve a marriage by the pronouncement of a talaq. Now, while of course somebody may say that that's unlikely to occur, or it might be somewhat far-fetched, well, I would, with the greatest respect, differ, because the overarching principle is compatibility with the Constitution and consistency with the Constitution and its values. And Section 9 of the Constitution and Section 10, which talk about equality and dignity, both sections could readily be invoked to challenge a legislative provision that allows for the pronouncement of a talaq by a husband to dissolve a marriage. So like that, one can envisage many a situation where Sharia principles which are now enacted in terms of a law of our country. Because you must remember, any legislation giving recognition to Muslim marriages is not legislation under Sharia law. It's now legislation under South African law. And once it's legislation under South African law, it is subject to constitutional scrutiny. And it's subject to the supremacy of the Constitution. So any law inconsistent with the Constitution is law that will suffer the fate of invalidity, the fate of nullity. And that is the sheer reality. Many of us have a fundamental problem with one essential issue, and that is this: that the law of the Almighty Allah, the law of Sharia, the law that comes to us from the Quran, and as expounded and supplemented by the teachings and in fact the injunctions of our noble Master Rasulullah sallallahu alaihi wasallam, we know that that law is sacrosanct. And the notion that the principles of the Sharia, which are given expression to in a law of this country, are now subjected to constitutional scrutiny as being subordinate and subject to the constitution of this country, that's fundamental anathema. That's in fact the problem. That can we see our way clear to allowing the courts of our country to test challenges that are raised by individuals within our own community who are seeking a particular outcome? That can we in fact allow divine law to be subjected to scrutiny through the prism of the Constitution, which is produced by creation? And that's the fundamental problem.